Hi, this is Steve Hubbard with AM VSR LLC in Alexandria, Virginia. What you're about to see is the capturing and the playback of a federal matter in the federal courts in Northern District of California, Jewell versus NSA, case number 08CV04373. Any courtroom in North America that is using video or just audio and streaming it live with great competence, with the best of equipment, will be able to capture and give real time transcripts to the lawyers and to the judge, no matter where they are and no matter where we are. This is the case summary of Jewell versus NSA. You can read it by pausing the screen or fast forward. In order to have a more enjoyable experience, we recommend that you maximize the window to full screen. We use OpenOffice 4. That's where ASR writes directly to this document. You'll eventually get that document as soon as there is a recess, an adjournment, so that you can now copy paste into your favorite word processor. You'll also have the interactive video where the sound is playing through the player, whichever player you choose to use.
Enable the court to make a correct and just decision. There are questions that arose when the court reviewed your papers, so they are real questions and there's no subtext or implied text, and in fact the court did not issue a tentative ruling in this matter because the court is completely open as to what it might do at this point. So the way I conduct these proceedings is, in this context, because we are recording the proceedings and the recording will not show the questions. Typically, I do not read the questions because they're e-filed with the parties in advance of the hearing. In this case, however, in these proceedings, I'm going to read the questions just so that the recording will contain the questions and the preambles that the parties are responding to. So typically, it's pretty clear that a question is addressed to a particular party, I will designate that party, and then I will give the opposing parties on the same side and the opposing parties an opportunity to respond and reply. It's an iterative process until the court feels like it has exhausted the question. You don't need to repeat and say, I really meant that when I said it the last time, because I'm obviously listening. And the other thing that I want, since there are other parties, there are multiple parties at least on the plaintiff's side, to the extent I will give any party an opportunity to respond to a question or reply, and then at the end I have some specific questions that are addressed to the distinctions between the two different cases. So it'll be pretty obvious as we go forward, but again, I just want answers to the questions. And at the end, you'll note that at the last question, which is question 12, I asked if the parties had anything further they wish to address. Now that is not an opportunity to change the procedure here or the protocol to reopen, but if there's something that was implied by the questions that you feel the need to talk about, or some matter that you feel needs to be said verbally, then say it. But keep in mind that the court has read all of your authorities, and so it's not an opportunity, except if it's in response to a question. You could say the XYZ case that we cited on page 3 or 4 of our brief, it answers your question, and that's perfectly okay. So again, I asked the last question with trepidation and advisedly about, is there anything more, because I have what I call the vacuum theory, which is that nature hates a vacuum and so do lawyers, and when given an opportunity to fill the vacuum, they will fill it. So those rules of physics don't apply in this courtroom. So without further ado, let's start with question number 1, and let me have come to the lectern both sides who'll be arguing that question, And again, I have absolutely no problem with counsel splitting up the answers or handling it any way you want. It's not a jury trial. So I will read the questions that I published a couple of days ago, just so that the record is clear while counsel is getting ready. So question number 1 is as follows. In Al-Haramain, H-A-R-A-M-A-I-N, Islamic Foundation, Inc. versus Bush, the Ninth Circuit specifically remanded to the district court to, quote, to consider whether FISA, F-I-S-A, preempts the state secrets privilege and for any proceedings collateral to that determination, unquote. And I cited 507 Fed 3rd, 1190, the pin site is 1206, decided by the Ninth Circuit in 2007. The district court in Re National Security Agency Telecommunications Records litigation held that FISA does not preempt the state secrets privilege. 564 Fed Sup 2nd, 1109, Northern District of California, 2008. In Muhammad v. Jeppesen Data Plane, INC, the Ninth Circuit, referencing the remand in Al-Haramain, found that, quote, Congress presumably possesses the power to restrict application of the state secrets privilege in the referral proceeding, unquote, citing 614 Fed 3rd 1070 1092, Note 15, Ninth Circuit 2010. So question 1A, which is going to be initially addressed to the defendants, is as follows. On what authority do the defendants argue the court should reverse the decision by this district court finding that FISA preempts
decision not to address 1806 really weighs one way or the other. Sovereign immunity, which is the ground they did decide the case on, is a jurisdictional issue. So it makes sense that they addressed that first, and having addressed that, did not proceed further. So we don't think it really weighs one way or the other.
All right. Anything further on this point?
Not on this point. Do you have anything?
Just one comment.
Certainly.
Your Honor. Matthew Brinkerhoff again on behalf of the plaintiffs in Schubert. I just wanted to point out, I don't think we have any quarrel on this point. Schubert is distinct from Jewell on a point related to your question, which is it was transferred as part of the MDL to this court, and therefore the law of case doctrine, I do think, as the government has acknowledged, does clearly apply to any analysis of displacement or preemption under FISA. And I think the government correctly stated the standard for law of the case, and certainly also correctly indicated that it is obviously not binding in the sense that a estoppel or res judicata or a binding appellate court decision would be, but it is the standard requires you to make a finding if you were to disagree with Judge Walker's opinion that it was clearly erroneous or constituted a manifest injustice.
Because it's why?
Because his ruling is the law of the case as applies to the Schubert matter, because it's part of the MDL.
All right. Anything you want to say in reply?
Just a couple of points, Your Honor.
Sure.
And my friend, Mr. Wiebe, argued a bit of the merits of the issue, and I don't want to violate your admonition not to do that. But if I could,
and especially because I attempted in the way the questions are worded to cover a lot of the areas, and sometimes they will overlap, and I'm trying to keep the discussion as much as possible confined to the questions.
Let me just give you just a couple of minutes on summarizing in response to his points.
Who's the his? There are two hises there.
To Mr. Wiebe's.
All right, thank you. No, I just want to know which point you're rebutting. Thank you.
This issue about FISA displacement has been before this court since 2006. We briefed it at length, and I think the plaintiffs are wrong, but as I mentioned before, I think there are very serious difficulties with going down this road, because if we do, our view is, and we've set it forth in our papers, that it would inherently risk the disclosure of the very information we're seeking to protect. But a couple of things about the theory of displacement I would just highlight quickly. One is that the law requires that Congress express its intent to displace the common law clearly and speak directly to the issue. This is clear Supreme Court precedent. And in this instance, Your Honor, we argue there is nothing in the text, nothing in the legislative history, nothing in case law, in short, nothing that supports the plaintiff's argument. Mr. Wiebe's argument takes this statute, one subsection of a statutory provision with 7 or 8 provisions, and he points you to 13 words in the middle of a subsection of a 6-subsection statute, and argues that by this, Congress intended to displace the most significant national security privilege in the law, without even mentioning it, either in the statute or in legislative history. We think that's entirely implausible. We think that you're required under Supreme Court canons to view the statute as a whole, in context, and when you do, you will see that this provision was intended to govern the use of the surveillance evidence against a person acknowledged to be aggrieved, and that the discovery motion that they cite fits neatly within that. Legislative history explains this very well. This statute is a fix to the problem that came up after the Supreme Court's decision in Alderman, when the Supreme Court held that if the government was going to use wiretap evidence against a criminal defendant in that case, although I'm not arguing this is solely a criminal defense issue, but in that case it was, and the Supreme Court held that if...
So download TeamViewer and make sure that it's operational, properly installed, and you will watch real-time transcription coming into your smart device. Download OpenOffice 4, and we will send you the actual document that you saw being created on your device. Now you can manipulate it any which way you wish. It's yours.